Many employers in Italy are purchasing foreign online certifications for workplace safety in just a few hours, yet they risk severe criminal penalties because these courses simply do not meet the real training requirements mandated by Italian law. The web is awash with platforms promising quick compliance with zero bureaucracy, but Legislative Decree 81 of 2008 operates on entirely opposite principles, creating an impassable legal rift. What exactly makes these certificates mere scraps of paper, and what tools has the Italian legislator put in place to ensure integrity?
This short circuit arises from a fundamental incompatibility between the global e-learning market and the rigid architecture of our health and safety legislation. When Legislative Decree 81 of 2008, known as the Consolidated Law, replaced the old Law 626 of 1994, it consolidated a critical principle. Prevention isn't an abstract universal notion. It's a process that must be tailored to specific corporate reality. International platforms typically sell standardized packages, often built on generic European directives or the diktats of the American agency OSHA, passing them off as universally valid. However, the Italian Consolidated Law demands sartorial precision. It requires a clear distinction between information, education, and training, concepts that foreign sites often conflate. The Italian legal framework rests on the state regions agreements, which dictate the specific rules for training. These agreements establish minimum durations, mandatory contents for each module, qualification requirements for teachers, and criteria for the accreditation of training bodies. A course delivered from a server in California or London, by its very nature, simply cannot align with these parameters. And when we move from theory to practical training, the gap becomes unbridgeable, resulting in outright illegality.
That terminological and operational distinction sounds absolutely crucial, as it appears to be where companies suffer legal collapse during inspections. Many are pushed towards these foreign courses not only for cost savings, but to escape the perceived complex bureaucracy of Italian paths, which require registered classrooms, certified teachers, and extended times. An entrepreneur might, in good faith, believe that showing a new hire a 20-minute tutorial, perhaps a foreign 3D simulation, is equivalent to properly training them on machinery. But you're suggesting this is a profound misunderstanding. What are the specific legal elements that prevent a virtual lesson from replacing authentic, hands-on training on Italian territory?
The legal elements are both physical and documentary. Education, whether in a classroom or via regulated e-learning, aims to transfer concepts, rules, and procedures. Training, conversely, transfers motor, operational, and perceptive skills. This requires direct contact with the risk material itself. Paragraph 5 of Article 37 of Legislative Decree 8108, profoundly modified by Law 215 of December 2021, closes every space for improvisation. The rule establishes that training must be carried out by an expert person and must take place in person at the workplace. It materializes in a practical test for the correct and safe use of machines, plants, substances, or personal protective equipment, including applied exercises to internalize safe procedures. The expert person doesn't necessarily have to be an external trainer. It could be a senior worker or an internal company supervisor, provided they possess solid, proven experience in that specific task. No virtual reality can substitute the expert eye of a colleague observing a worker operating a press brake, correcting the posture of their hands. But the real barrier against foreign courses introduced by Law 215 is the obligation of traceability. Every training intervention must be recorded in a special register, even in digital format, detailing dates, topics, and signatures. Without this register, an international certificate loses all meaning before the law.
This introduction of a dedicated training register fundamentally alters the balance of corporate responsibility. Before 2021, On-the-job training by expert personnel was mentioned, but the lack of a specific documentary obligation made verification difficult, often relying on witness statements. Now, if it's not written and signed, by law, it never happened. Yet, even setting aside practical training and focusing purely on theoretical education, the market for these easy certificates persists. Many employers still rely on the rhetoric of mutual European recognition or international standards, believing that a 4-hour course passed on a portal in Munich or Madrid has universal validity. Are there precise regulatory mechanisms within our system that specifically reject these attempts at training importation, even for theoretical aspects?
Yes, the rejection system is integrated into the very nature of the state regions' agreements. In Italy, safety training isn't a free market where anyone can simply declare themselves a teacher. The agreements, stipulated within the Permanent Conference for Relations between the State, Regions and Autonomous Provinces, outline a closed perimeter. A certificate issued abroad is rejected because it doesn't meet the institutional accreditation constraints. To deliver valid training and certify skills, an entity must possess rigorous requirements, often requiring formal accreditation with the specific region in which it operates, unless it's part of authorized national categories like universities, joint bodies, or more representative trade unions. The recent State Regions Agreement 59 of 2025 has further tightened these protocols, unifying training regulations for employers, managers, supervisors, and workers into a single text. International providers have no awareness of these bureaucratic stakes. They don't align their modules with Italian mandatory minimum content, they don't structure learning assessments according to our criteria, and they use instructors who don't respect the parameters dictated by the Interministerial Decree of March 6, 2013, which imposes specific academic, training and professional experience paths to teach safety in our country.
So the qualification of the teacher effectively acts as a training customs barrier. A brilliant British safety engineer can't just record a video and certify workers at a steel company in Brescia, for example, unless they can prove they possess the qualifications listed by our interministerial decree. This regulatory closure also significantly impacts foreign companies operating in Italy. A German company subcontracted at an Italian construction site cannot rely on its national safety cards. It must comply with Title IV of the Consolidated Law and demonstrate training equivalent to our standards. But there's a specific figure that particularly feels this tightening of the rules: the supervisor. We're talking about the person who oversees activities, checks directives, and intervenes if a worker isn't using protective equipment. For too long, supervisor training was delivered through sterile, pre-recorded online modules. How has the framework for supervisors changed, moving away from foreign models based on the automation of certificate issuance?
The case of the supervisor truly embodies the legislator's will to eradicate window dressing training. Article 37, paragraph 7 ter of the Consolidated Law, modified by Law 215, introduced a clear break, which the new State Regions Agreement 59/2020 has now codified. The training and updating of the supervisor must take place exclusively in person. The reason lies in the sensitivity of their task. They must develop relational skills, authority, and readiness to stop dangerous work. Skills that are simply not acquired by passively watching a screen. Asynchronous e-learning, the model upon which the business of rapid international courses is based, is explicitly prohibited for this figure. The only exceptions granted are physical presence in a traditional classroom or the use of synchronous video conferencing. The latter is equated to presence only for the theoretical part, as it guarantees continuous interaction between teacher and student, allows for real-time questions, and ensures constant monitoring of attention. So, if a company relies on a foreign provider by purchasing recorded packages for its foreman, it is committing an obvious offence that inspection services will detect at the very first.
The ban on digital delegation becomes even more inflexible when the focus shifts to highly critical work. Think of workers destined to operate in confined spaces such as tanks, silos, or sewage networks, or those who must drive heavy and complex machinery. The web is full of offers to obtain a so-called license for the use of an excavator or an aerial platform through questionnaires that can be completed in 20 minutes from the comfort of home. This is a trivialization of danger that borders on the paradoxical, especially when a lack of dexterity at the controls of a forklift can lead to fatal accidents on real construction sites. The theoretical phase in these scenarios is a necessary precondition for accessing the core part of the training path, the field test. What are the regulatory barriers raised by the new State Regions Agreement of 2025 to ensure that operators of special equipment and workers in confined environments receive measurable and verifiable training?
In high-risk contexts, Agreement 59/2025 eliminates all ambiguity. For work in confined spaces, the legislator has established that previous training is recognized only if it fully meets the new, stringent requirements. If not, the path cannot simply be integrated. It must be repeated in full.
For work equipment, the agreement establishes a strict dichotomy between theory and practice. The theoretical technical module requires teachers who not only boast the general requirements of 2013, but also possess specific technical knowledge of that single machine. The practical module, crucially, requires trainers with a background of direct and certified experience in the use of the equipment. This entirely zeroes out the validity of international multiple-choice tests. The operator must physically get on board the machinery. They must perform the checklist of preliminary checks, simulate maneuvers empty and loaded, and manage emergency shutdowns, all under the watchful eye of the instructor. Certificates issued according to the rules of the 2025 agreement assume national validity, but only if the entire process, from the duration of the sessions to the teacher's qualifications, right up to the field verification methods, has been precisely respected. There is absolutely no room for internet shortcuts.
The analysis of this regulatory framework inevitably leads us to the evaluation of the legal consequences. When an entrepreneur chooses the path of low-cost international courses, they are not just facing a mere risk of bureaucratic or administrative nature. What are the true legal ramifications, particularly when an accident occurs?
Violations of the Consolidated Law on Safety take on criminal relevance, typically in the form of a misdemeanor. The gravity of the situation explodes the moment an accident occurs, perhaps with permanent injuries or even a fatal outcome. In court, the absence of compliant training and the lack of a training register turn into what the text describes as accusatory boulders. A certificate lacking the legal hallmarks required by Legislative Decree 8108 proves that the employer operated with gross negligence. Choosing the path of savings or speed by relying on unrecognized providers effectively means providing the judiciary with proof of one's own organizational guilt. The jurisprudence of the Court of Cassation is consistent and merciless on this theme. Sentences reiterate on every occasion that the obligation of education and training has a substantive nature. The employer's duty doesn't end with the purchase of a service. It is realized in the verification of its actual adequacy with respect to the concrete risks present in the production cycle. The absence of the register of training interventions made mandatory by Law 215 of 2021 serves as documentary proof of practical non-compliance. Without that register, there is no way to prove the worker was guided step by step in learning correct postures and safe operational procedures. There's a further element of guarantee in the new State Regions Agreement 2025, the evaluation of the effectiveness of the training activity. The rule pushes companies to adopt study models on accident incidents, analyzing not only accidents but also near misses before and after training. This approach proves that training commitment must be measured on concrete results in the long term, dismantling the logic of the single virtual lesson brought abroad to simply fix the paperwork.
The distance between documentary appearance and true operational competence really does represent the essence of the entire Consolidated Law on Safety. While the convenience of rapid international courses attracts many companies looking for easy solutions to complex obligations, workplace safety in Italy allows for no discounts. It is an impermeable legal system structured on detailed regulatory agreements, qualified teachers, irreproachable training registers, and mandatory practical checks. Attempting to evade this system with foreign e-learning certificates is equivalent to jeopardizing the health of employees and the very continuity of the company, exposing oneself to investigations and criminal trials. Please share this episode with a colleague to highlight the real regulatory requirements and avoid the dangers of fake safety certificates.